Well, Ben, I think let's start with that. If you want to just give a brief introduction about you and your firm, and then we can go from there.
Sure. Good morning, and my name's Ben Martin, and I'm an attorney in Dallas, Texas. That's my home, and I practice law across the country. I have cases across the country, licensed in uh, Pennsylvania and Texas, and then we get temporary licenses and wherever we go to practice all over the United States. I've been in the practice for coming up on 40 years and have been doing mass tort and pharmaceutical medical device cases for many years.
Amazing. And Ben, before we dive into kind of how you and I met, you work differently than most of my clients, and you're awesome to work with, but so is your team. The campaigns that we've been running together, I don't think it's a secret that you focus on a few lawsuits, mainly around Depo-Provera, a little bit of rideshare abuse, some bed sores, nursing home abuse. As we've wrapped up 2025 and as we now are into 2026, what mass torts are you focusing on this year, and what do you think is going to dominate your practice in 2026?
So we have about 10 to 15 different types of litigation that we do. I started out in the practice of law doing medical malpractice and general personal injury work, and did that for several years and learned the ropes and tried a lot of cases. So the practice is really kind of it's specific insofar as what we're focusing on a day-to-day basis, but it's also general in that we do basically any type of cases that involve injuries to people, right? And so, but at various times, we some cases are on the beginning end of the case, and some cases are towards the end of that particular litigation, and sometimes you don't know either one, right? So, I would say that we've got a good number of different areas, but right now at the moment, what I personally am focusing on are things like Depo-Provera. It's a big deal right now, and it's a big deal for us. It's a big deal for our clients. Also, the decubit ulcer cases, bed source docket, the never event cases, hospitals and physicians and nursing homes are involved in those cases. And then rideshare and sexual assault cases where you've got institutional responsibility for these horrible assaults that occur both in the area of rideshare with Uber and other rideshare programs, and then you've got our platforms, and then you've got unfortunately sexual assault seems like it's an epidemic now, right? So those are just some areas, paraquat and pesticide litigation. If you think of a type of litigation, IVC filter that has involves a medical device, there are a lot of those cases that arise when we find out that the companies are either not knowledgeable or are knowledgeable about the problems and then don't follow through with what it takes to take care of those problems.
That makes complete sense. And sometimes I have different attorneys who's looking at my content, and they come to us for certain help with their case acquisition, but they're also looking to gain better connections with firms and people like yourselves. What do you think is one misconception to people new to mass tort about running mass tort practice over maybe an MVA campaign or a personal injury campaign?
And one of the conceptions is that, and this happens when I talk to clients sometimes, especially at the start when they don't really know anything about it. I kind of need to explain maybe a little bit about what happens in one of these uh, mass torts or this pharmaceutical cases. And Sebastian, what really happens is our firm anyway, we litigate the cases, we try the cases, we do represent sometimes hundreds of people, and in some instances even thousands of people who have been tragically injured by some product. People think, and even other lawyers who don't know this litigation think that these are, I hear the term class action, right? That these cases are class action. Ben, do you put these cases in a class action? Class action is something completely different. What I think is important to focus on is, even if you represent a good number of people in litigation, it will be because you've developed expertise in that field, expertise in that particular product, expertise in what injuries it causes, and all of the science involved, right? In Depo-Provera, for instance, there is a body of literature, medical literature, that shows that you are about 6 times more likely to develop a brain tumor called a meningioma if you have been injected with this particular birth control product, as opposed to if you had never received this birth control product. So you've got this concept, to get back to your question, Sebastian. You got the concept of, well, you've got a lot of cases, and you file these cases, and then you just kind of wait and sit back, and maybe a judge will order that there's a class action or something. These aren't class actions. The thing about representing people in these cases is you have to treat every case on its own merits, right? You may have a litigation that has hundreds, possibly thousands. There have been tens of thousands of cases filed in some of the litigation, like the 3M earplug litigation, right? But they're individual cases because they're individual people that we're representing, right? So they all have to be paid attention to. And so it's not like a class action where you have 5 or 10 or 15,000 or hundreds of thousands of people that go into one single court, and then their fate is kind of sealed with whatever happens with a little class action, resolution. That's not any of what we do. When we get a case, whether it's a Depo-Provera case or whether it's a single bed sore case, things like that, we encompass, we delve into what's the science, what's the causation, what's the relative risk, things like this that tell us, well, number one, is there even a case to look at? And then if it turns out that what we find a lot is, in fact, there is a problem with a product, then we delve into the details of the science and the medicine and the individual facts of the individual cases. So a long-winded argument or a long-winded statement to you to answer your question, Sebastian, is the chief misconception that I get when people ask or talk to me about these cases, these mass tort cases, or these pharmaceutical cases where tens or hundreds of people are being represented, is that it's considered by a lot of folks just as a big class action, and the individualism and the individuals aren't being looked at. It's different with what we're doing.
For sure. And doubling down on Depo-Provera, towards the end of December, there was news around the labeling and the warning around the specific brain tumor that you're talking about now. So now the manufacturer is going out and warning about the risks associated with the birth control. What do you think that does for the litigation as a whole?
Well, one of the arguments that the defense was making, that Pfizer was making to the court, and we haven't gotten into details about where the cases are filed and all of that stuff, but there's a court in Florida that is the multi-district litigation court where a lot of these cases have gone. Not all the cases. I've got cases filed around the country that will never see that MDL. I have cases in the MDL, right? One of the arguments that was being made by Pfizer for the first 9 or 10 months, and quite frankly, it's still being made, but a lot of things have happened. They were making the argument the federal law preempted, in other words, disallowed any of these state court claims or these claims that people were injured by Depo-Provera, right? The basis of our suits is that Pfizer knew or should have known that Depo-Provera created a multiplier of risk of the development of a particular brain tumor called meningioma. And so
Mm.
what happened was Pfizer then approached the court and asked for a preemption order, saying, "Judge, dismiss all these claims. These can't be brought under federal law." And one of the main arguments was that, well, we couldn't really get a warning from the FDA. The FDA wouldn't allow us to have a warning. And then the opposite view was outlined, and it turns out that the FDA now has actually issued an order that they are to warn the public of the concerns with meningioma. Whether or not that particular warning is good enough may be a question, but the fact that they warned of the fact that the FDA has told them you must warn about the risk of meningioma in a certain aspects of it, that is goes a long way with proving that they should have warned, could have warned, and did not warn about this product and the problems that Pfizer certainly knew that it increased the risk of the development of a pretty significant problem. I mean, a very serious problem, very tragic problem for the women who have it. And to see let me just say, back last year, actually now year and a half ago, March of 2024, there were some scientists that studied a large population of women in France, over 100,000 women in France, and determined, comparing the women who had the Depo-Provera versus the people who did not have the Depo-Provera injected into their bodies, they found a 5.6 times relative risk, meaning a 560% more probability that the women who took the product would develop a meningioma as opposed to women who did not. So I don't know if I've answered your question about the warning, but now the FDA has issued a warning. Now Pfizer's, it's difficult for them to say it was impossible to issue a warning because a warning's been issued, right? And so that's really a major import to that warning. And if you don't have a warning, the warnings go to the doctors and the patients. So when a doctor has a conversation with the patient before they inject any drug or before they do a surgery or before they treat a patient with a specific pharmaceutical, the doctor will have what's called a risk benefit conversation with the patient. And that risk benefit conversation should include all of the important risks. If the label for the product does not contain the risks, doesn't warn the doctor, and if the doctor otherwise doesn't know about the risk involved, then the doctor can't convey that risk to the patient. And there's a complete lack of information about the patient has to be given the full information on a product in order to be able to actually determine whether or not they want that product in their body. And if you don't have a warning, then the doctor can't impart that risk or that warning to the patient because it's not there. And that's the problem with the lack of a warning.
Which is absolutely terrible. Which is why you're doing what you're doing. And Ben, just outside of this recording, I want to anchor you as an operator and as a leader, not too much of a marketing case study. So as we talk about these lawsuits, and as we talk about Depo-Provera as an example, and as we talk about the litigations, even before you get your cases in, you work them up. You have to get the cases in, right? You have to work with a marketing vendor who can generate these cases and these possible plaintiffs for your firm. Talk a little bit about, before working with tort experts, what were the biggest challenges you faced acquiring cases in mass torts?
Well, without going into any detail on specific companies or specific problems with particular folks, let me just say that uh, in Depo-Provera, there it turns out that there were a significant number of folks that we were talking to, potential clients that we obtained, and we discovered that that things weren't really panning out, and that they weren't that maybe these folks, some of the folks, had not actually taken the drug or hadn't been injected with the drug. Maybe some of the folks didn't really have the meningiomas. I'm gonna say that in certain respects, we were finding some people, not all people, but we were finding some people that were were not real. They didn't have real injuries. They didn't take the drug, and we were kind of becoming aware that there was a problem there, and I think there is a problem in um, in obtaining these cases by certain vendors who are out there generating these cases, that they're problematic because they're not real people. The folks that they're signing up are not real people. There are that's a big problem in not just this litigation, but I'm seeing that or this Depo Provera, but I'm seeing it in other litigation too, where somehow, so for some reason, people are they're not real people. Now, this is hopefully at the end of the day a small number of folks, right? That are because there are a lot of people that need our help, a lot of people who are seriously injured, but there are some people who were getting into our offices that it turned out that didn't have the meningioma or didn't take the device or didn't have the injections. So that became a problem, and quite frankly, Sebastian, it's a problem with some of the vendors that do what you do, uh, uh, and but that don't have the abilities or the abilities, wherewithal, desire, whatever you want to call it. Some folks, I'll say, you're in your business of advertising for these cases and marketing for these cases, are not as strong as others, and that's kind of putting it lightly. So does that kind of help you a little bit?
Yeah, no, for sure. And I talk about this a lot in terms of, and you haven't said it explicitly, but there's a lot of fraud in the industry, right?
There's a
As a
lot of
legal
fraud.
marketer, people are putting coach people, they're putting profits over people, they're putting profits over their clients. And I'm trying to put an end to it, frankly. I'm sick of hearing all the fraud. I'm sick of people taking advantage of the law firms, the funders, but I'm sick of people um, doing unethical advertising in general. And I talk about it a lot on my social platforms. I talk about it a lot with my clients because the reality is, if somebody's not going to stop it, it's going to keep going on, right? And therefore, when we work with our clients, when we work with your firm, Ben, and others, we set expectations from the beginning. We don't want to, have a chase to the bottom when it comes down to cost, but we also have the manpower to not only do the marketing ourselves, but also handle the intake ourselves. My team, I have a team of 16 intake agents onshore that I'm paying a significant amount of money. I could probably go offshore and save money and margin and pocket a lot more, but I'm not interested in doing so. And more importantly, after intake, before they hit Ben's firm, we quality assure them. Because the reality is, even when we handle everything end to end, there are bad actors that are trying to grab a paycheck. And we have to put a stopper to it and be able to give Ben and give our other clients the best possible claimants so they can go out and hold these large corporations accountable. When it comes to the other vendors, we don't have to name any names, we don't have to name any people. At what point did you realize, Ben, that it wasn't really the volume that was the answer? It was more of the opposite, right? Working with the right people, but getting the right quality over quantity.
Before I met you, Sebastian, and just to be real straightforward on this, before I met you, we had used other vendors in this litigation to uh, ethically and honestly and with complete transparency obtain cases so that we can represent people and help them, right? And unfortunately, what we found is a few months down the road, we were finding there's a lot of red flags. A lot of red flags that it's like, uh, why are we unable to get a hold of our client? Why are we unable to get the answers that we generally are able to get immediately? Well, why the refusal of certain folks to just follow through on basic information requests, and that led to the red flags of, that these aren't people that we can help because these people never were injected with the drug. And what we found out is that there were no controls being used for that these particular folks that are out there getting these cases, and there's a lot of fraud. So that was the red flag probably a few months into this, and by uh, coincidence, by things that happen, then ultimately we are in touch with you. We've got another great vendor. We'll not talk about specific
Oh
vendors,
no.
but Sebastian, we've looked at what you do, and we've looked at what folks like that take their job seriously and aren't at it just for the money to a quick buck. And we see that there are ways to prevent the fraud. We see that there are ways to go forward with the cases and help people, because there are a lot of people who are hurt. So the problem is, if we're dealing with cases and dealing with vendors and all of this fraud, it takes the time away from us and really being able to do something for the people who really are hurt, and
Hmm.
the people that we're out here to try to help.
For sure. I think just to tie a bow, Ben, because my audience, I call it my ICP, my ideal customer profile. I want to be the go-to legal marketer for any mass tort and personal injury attorney out there. Because, as you've said, there are so many bad actors out there. There are so many bad vendors out there who are just looking to make a quick buck. I've been doing this for 10 years. I want to do it for the next 10 as well. I have law firms, attorneys coming to me and saying, Seb, I want to fund XYZ lawsuit. Who should be my co counsel? Or on the opposite, hey, Seb, I can really litigate this lawsuit. Who can get me more cases, right? What advice would you give law firms and other attorneys considering to scale their mass tort practice when it comes to the lawsuits that you're focusing on?
So if you're from my perspective, and I've been at it a lot of years, as you know, and obviously, just the number of years I've been doing this. Sebastian, if I were a young lawyer, um, or not so young lawyer who had not been in this space, as they call it, the mass tort space, the pharmaceutical space, the medical device litigation space, right? Or if I weren't heavily involved in litigation and I wanted to get involved, for instance, I think that's kind of what you're talking about
Mm-hmm.
here. With what you want is you want to be able to make certain that your clients if you're going to um, say joint venture with, or you want to co-counsel with another law firm or lawyers, you want to make sure that they have a background, and you want to check the background of of what are they really doing? Are they saying they're litigators, or are they saying they're trial lawyers, but they've never been to trial? We tried 17 cases during COVID, 17 pharmaceutical uh, litigation cases in the form of IVC filter and other mesh products. And we go into federal court, and the judge would say, "Put your mask on and call your next witness, Mr. Martin." And so that's the reality of
Hmm.
um, firms who actually do the litigation. You want to make sure that somebody's been down at the courthouse a few times in this type of litigation. I would say that's the main thing: is what is the experience of, and what is the level of trial experience, and trial preparation that you're talking about. Number two is that trial experience and litigation experience in the area of the mass tort that you're looking at, or the particular pharmaceutical or medical device product that has injured your client. Because if you want the best result for your client, you need a lot of warrant, where you need to hook up with folks that know what they're doing. And when I say that we tried 17 cases during COVID, okay, most of them to verdict, then what does that mean? Well, you represented hundreds of people in the particular uh, IVC filter litigation. You represented folks in the mesh litigation, lots more than the numbers that were tried. But the way it works is because you work up every case as its own, and they all become individual cases. And if the cases are remanded to the trial courts, then you go try the cases that are remanded. And ultimately, those trials may benefit your group as a whole, but you really must think of these things as individual cases, or else you're going to be shooting yourself in the foot. You need to prepare each case that you have a trial setting on as if it is the only case, because in that courtroom, it is the only case. When you try a lawsuit, you're trying a case for a client. You're trying a case against a company, usually a big medical device company, and or a pharmaceutical company, and you're trying that case with that client. And it's a human being. It's a person who has been hurt, and it's in most instances a tragic thing, made more tragic because of the knowledge that the companies sometimes have of the very condition and the very cause of the condition, which is their product. So when you're in the
Hmm.
courtroom and spending weeks in a trial, uh, you have one client. You don't have thousands of clients. Then you have one client. That client's the one that the jury's going to hear about, and it's the case that you're going to be trying for that person against that pharmaceutical company
That's
individually.
right. I think, and what I'm trying to foster is a different mentality from the firms, the Bens that we're working with, and go from a vendor to more of a partner in legal marketing. And I'll give a great example from working on Depo-Provera with Ben. Initially, early on, when we run Depo-Provera for a long time, even prior to working with Ben and his team. Um, and one of the differences that we saw in doing the marketing and doing the intake and the quality assurance is a lot of these cases in women didn't know the brand of the injection, of the birth control. So when we generated leads for Depo-Provera and signed them up, we actually disqualified a lot of women who had meningioma and did have a birth control injected. They just didn't know the brand. And within the criteria we worked within from the firms we worked with at the time, they only required a certain brand, and they needed that to be confirmed on our side before we could pass them the plaintiffs, the cases. And when my intake team sees a requirement to confirm the actual brand, we reject it. And the reality is, we rejected hundreds of valid cases and valid women who had brain tumor, who had meningioma, but they just couldn't recall the birth control injection brand. When I and my team reached out to Ben about this issue, he actually took it seriously and said, "We will look into it." He sought advice from experts, and actually found out that when women received this birth control and injection, the doctor didn't go in and come into the room and said, "Hey, this is the brand of the injection. Are you okay with it?" They just injected you with it. And as a result, Ben changed the criteria to not require we want the brand of the birth control, or the birth control injection ideally. But if they couldn't recall it, it wasn't a game changer, because after we sign up the claimants and quality assure them and pass them to Ben's team, he gets the records and he confirms the brand of the actual injection and the birth control. And he can confirm the fact that most of them actually were within the brand that he was looking for. And that hurts me in the sense of, we oftentimes are at the bottom of the food chain as legal marketers, and I'm fine with that. We work for the law firms. We try and help them to the best of our ability. But what I'm trying to foster, and what I've been successful with for the past few years now, is to switch the vendor mentality to more of a partner mentality. So when I come to Ben, or when I come to my other clients, they do take it seriously when I have a point, or my team has a point about a serious matter, because we're not trying to cut corners. We're trying to better the process for the clients that we're working with. And I think the transactional marketing is dying, at least within legal marketing. And I'm really trying to align the goals better, to be better, to come with better tactics, but also because of the shared accountability versus just outsourced blame. And many of my current clients, Ben is a phenomenal example, and the Depo-Provera injection is a phenomenal example of how we've been able to pivot but still be successful. From your experience, where do you see firms losing the most money without realizing it right now?
Got to pay attention to the cases coming in. If you don't pay attention to the cases coming in, then you're starting out behind the eight ball. Just kind of what we were talking about, Sebastian. You gotta
Totally
have
agree.
real cases.
Yeah.
You gotta have real cases. You gotta have real clients in order uh, to to uh, to help the process. Not just help the process. You can't represent a fake client, right? So vendors that pay attention like you in getting cases, they that's number one. Make sure of what's coming in, and make sure you have good control over the dialogue. Make sure that you talk to clients. Make sure that you stay in touch with clients. Stay in touch. Have a program to stay in touch with those clients, because some clients, even though you got a contract and you've had communications with clients, sometimes. If a week goes by and they haven't heard from you, or a couple of weeks, and they just wonder, well, what's happened with my lawyer, and some folks forget they've hired you. So you gotta also keep up with your clients and pay attention to your clients, because if you do that, the chances of attrition, you say, for your clients just leaving and hiring another lawyer, it's largely because they're not having the communication that they want to have, and they're not able to get information from the lawyers that will be able to give them an update on their case and what's going on. And sometimes you're spending a lot of time on things behind the scenes that the client doesn't know about. And a lot of times, the things that you're doing behind the scenes, uh, you're going to be doing it without the necessity of a particular conversation every time you do something with a client. A lot of the times, this is going to be research. A lot of times, it's going to be investigation. both on the individual facts and of the case, and also the general facts. What's the science say on this? What's the current medical literature on this? You're working all the time on a particular case, but you're not having to involve the client. But you nonetheless want to at least make certain that the client understands that there are things going on. People want things to be going on in their cases. People want cases filed. People want the litigation to move along because, and you want to be able to do everything you can to move the litigation along, because delay in everybody knows that delay in the legal system is a big problem, and it can be a problem with cases involving hundreds or possibly thousands of people, because it's just impossible for there to be 1,000 trial settings at one time, right? And so there's a lot of things that you can do to make sure that you're keeping up with the clients, informing the clients, and that they feel comfortable that they've got a lawyer that's pays attention to their in these cases very tragic and serious situation.
And how do you do that at scale?
You just have you institute policies, firm policies. You institute tickers. We used to call them that. Every so often, a client is contacted. You want to keep up with the client and make sure that they you have their current address, just to get granular. What's their, or have they changed email addresses? Have they changed phone numbers? Have they changed physical locations? Do you have a system? It's all about the system, and it's all about organization. Do you have a system to be able to keep up with your clients? And that's all it is, Sebastian. It's just a system. It's just all organization from start to finish.
I love that. And I think that's where some people, at least, and I fully agree, I think it's where firms lose the most money right now without realizing it. Is the first one is the cases coming in, not keeping an eye on the quality of the cases coming in. But secondly, the quality of the cases coming in, they have to be nurtured. They have to be worked up. They have to be, they're real people. Ben, what's been the biggest win of your career?
So there have been wins that I've been involved in. If you're talking about verdicts, I've been involved in the trial of cases where we've gotten nine-figure verdicts, right? Eight-figure verdicts. Last year and a half ago, we got an 18-19 million dollar verdict in Dallas in a tragic case. Uh, uh, Involving, in that particular case, involving a family that had severe injuries, and we tried that case. The verdicts, we've had a lot of verdicts. We've had a lot of good verdicts. We've lost some cases, and sometimes if you're going down to the courthouse and you're not ever losing a case, that means you're settling for pretty cheap, right? You gotta go try your hard cases too, Sebastian. But if
Mm-hmm.
I can rattle off a bunch of big verdicts, but that's really not as important as my biggest. When I'm asked about, well, what's your biggest win? My biggest win, honestly, is helping people and changing the conduct, and having something to do with changing the conduct of big corporations, big pharmaceutical companies who need, for instance, they don't have a label. They don't have the proper label. I can tell you that I've done work in IVC filter litigation where we've gotten verdicts. We've tried cases. We did a lot of research, did a lot of discovery. Been in that litigation for 10 or 12 years. I'm co-lead in an MDL uh, in the Cook IVC filter litigation. That litigation is in its 11th year. And so, but in that time period, uh, for all of those different filter manufacturers, I believe that we were instrumental. I was instrumental, along with others, in making a change by doing what we needed to do. And I think we've pointed out some really strong, some really great things that were unfortunately tragically overlooked. The IVC filter is a medical product placed in the inferior vena cava, the largest vein in the body, and it's meant to stop pulmonary emboli from going to the heart. It's a very serious medical condition. We were able to establish through just the passage of time and the medical literature that came out that, in fact, one of our experts in the litigation established, and it was written up in the annals of internal medicine, an article that proved that there were problems in the in imparting knowledge on the part of the uh, medical device manufacturers to doctors and to the public. And there's a fantastic article that came out in one of the most major medical journals that exists that explained that was part of what we had done in that case. And that IVC filter case did lead to the information that these fine scientists were then able to get a hold of and issue that peer-reviewed article. So I'm proud of that. That's one of my that I would say
I love that.
my
I
biggest
love that.
case. Did that involve a $150 million verdict? No. What it involved was being able uh, to change things, right? The changes in
Phenomenal.
labels, all of that stuff. That's what I feel the proudest of.
I love that. Helping people, holding big corporations accountable. If you had to sum up your experience with working with tort experts, what would that be?
I would say, Sebastian, number one at the top is integrity, and I'll say very close second is transparency. I believe in that, not just in the practice of law, but hopefully in the way we go through things in life. And without any question, integrity is the most important, and you guys have it, and some don't. Transparency, how you deal with your partners and your folks that you deal with, and lawyers. Transparency. You got to have you got to have total transparency in these dealings. Not everything goes according to Hoyle, as we talked about, and so transparency, integrity.